I am struggling with this TikTok studio, so really doing my best. But we're going to be going over, awesome. So we're going to be going over the Code of Ethics, Section B. So the other night, 2 nights ago, we went over Section A. But Section B on the Code of Ethics is confidentiality and privacy. Let me know if you can see the request box, because I want to welcome folks up tonight if they feel comfortable. You don't have to show your face, but hey, it's a good way to be engaging. If you want to add or lift something to the room or the space tonight, you are more than welcome to do so. So I like to review the mission. So the mission of the Code of Ethics is to enhance the quality of life of life in society by promoting the development of professional counselors, advancing the counseling profession, and using the profession and practice of counseling to promote respect for human dignity and diversity. Okay, so that's a lot of words to just basically say. This is so that we can gatekeep our community, our counseling profession, so that we can protect our clients. Okay, that's a lot of words to say that, right? We want to make sure that the therapists or the counselors that we are sending out in the field are professional, that they are able to acknowledge, and not just acknowledge, but respect the dignity of our clients and the diversity of clients. Okay. And so 2 nights ago, we went over Section A, the counseling relationship. And so tonight we're going to focus on confidentiality and privacy. Okay. Let's hop right into it. So B1 is respecting clients' rights. Now, okay. I feel like I want us to focus on knowing that confidentiality is not just a code, but it's a promise. Okay. When we are in sessions with our clients, we have to promise that what they share with us stays between them and us, unless, right, we went over the limits to confidentiality 2 nights ago, unless they are danger or harm to themselves or other people. Okay. So when clients walk into the therapy room, they're trusting us with the things that they've probably never told anyone. And so our jobs is to protect that information. All right. But there are situations where we are legally and ethically responsible for what they tell us. So some things we cannot keep confidential, and that's just part of the process, right? That's part of the relationship. And so on tonight, we're going to talk about those lines, because this will help you, Tosh, as you are grappling through the questions on the NCE. All right. The goal is to not memorize. So when you think of the ethics portion of the exam, it's not about memorization. It's mostly about being able to recall the values that lie underneath these ethics codes. All right. Let me know, thumbs up if you got it, if we're ready to move on. And we're going to spend time explaining it like we are talking to just other therapists, right? Because we want to make this something that we can understand in terms that we understand them in, okay? The limits to confidentiality is something that every therapist should be discussing, right? We got to discuss it, right? So let's look at the B1A, the multicultural diversity considerations. So here it says that counselors maintain awareness and sensitivity regarding cultural meanings of confidentiality and privacy. And counselors are to respect the differing views towards disclosure of information. And so counselors have to ongoing. So this is something that needs to be ongoing. Disclosure, consent, and respect of client rights is not a one-off. It's an ongoing part of the counseling relationship, period. Okay. We have to discuss it with our clients. We have to let them know the hows, the whens, the whys, and with whom the information needs to be shared with. Okay. So in particular, let's say you have mandated clients and you know that what you are writing in your notes and your EHR systems need to be shared maybe with their parole officers or with courts, we have to let them know that. Okay. If you're working with kids, after you've obtained the assent from them and the consent from their parents, because they are not legally of age to give consent, we still have to explain the limits and be aware of the diversity and the multicultural considerations. Okay. It's a must. We absolutely have to, okay? And then the clients have a respect for privacy, right? So as the therapist, we have to respect our clients and their privacy. And so we have to make sure that the information that our clients share with us is kept private, and we only need to discuss it if it's beneficial for the counseling process. So what this means is, let's say that there are different folks included in the counseling environment. So you have like the client that you're working with, and maybe there are some outside folks, right? Even if they join the session, let's say your client is a child and their parent joins the session, and it's not a family session, but it's just the session that the parent is in, you still want to maintain and respect the privacy of that client. So maybe some personal things that they've shared with you, you're protecting that information because you have to respect their privacy, right? You only are bringing up the relevant information that is pertinent for whatever session is happening, okay? We got to know that we cannot be blabbermouths. We can't, okay? And now, so B1C, it goes into respect for confidentiality, right? So as the counselor, you have to protect the confidentiality. So like all the information that a client is sharing with you, it must be protected. And then let's say that like you have consent from a client, you can only disclose their personal information if they give consent for it. You cannot just share information just because. And I think that the lines get blurred when it comes to like therapists working with kiddos. Just because they're underage doesn't mean that you need to be telling their parents everything. If they're coming to session to see you, parents don't need to know everything unless they tell you that they want to harm themselves, they cannot be safe, or they want to harm someone else. Okay? Give me a thumbs up in the chat if you are following. B1D, the explanation of limitations. So here's the thing, right? We have to maintain confidentiality, but there are limits. All right. There are limits to confidentiality as a therapist. There's no way that like you can keep something a secret if you know that the client is going to do harm to themselves or other people. Okay. And you have to explain this throughout the entire counseling process. It's not a one-off situation, because let's say that a client comes to you one day, but then maybe they're having a great week. And then the next week, things are different. And then the following week is even more different. And so on and so forth. This is something that has to be ongoing. Is you want to make sure that you have like the welfare of clients at the forefront. All right. Welcome in. If you're studying for the NCE or CPCE, you're in the right place. We're going through the Code of Ethics, Section B. Now, let's go through the exceptions. We kind of already talked about it, and some of this stuff is like, I would say common sense, but like maybe not so common sense, because here's the thing. We don't know how to judge. Like the only time that we have to make an extreme action of sharing information that's private is when there's a situation where a client wants to seriously harm themselves, there is imminent danger, foreseeable danger, right, or legal requirements. So when we were talking about the counseling relationships, the ethics code in A, we were talking all about the relationship, the counseling relationship, right? But there are times when we have to break confidentiality as clinicians, and that is to keep our clients safe. Confidentiality will never apply if we know that a client is actively going to be harming themselves or other people. If they disclose any situation that reads imminent danger, you are responsible of reporting that information, whether that is reporting it to the law authorities. If you work with kiddos, it could be a family, legal guardians, right? If an adult client discloses that they want to go and harm another adult, it's your duty to figure out how to get in contact with that adult or the authority to let them know, okay? I feel like the biggest thing here, guys, is counselors need to consult with professionals when you're in doubt, right? I will say, rule of thumb, if you rather be safe than sorry. There's a lot of discourse about like overreacting as clinicians, and maybe like how like clients are very fearful of telling their therapist that they feel like they want to harm themselves because they're afraid that their therapist is going to call the police. Sometimes you have to use common sense. You also have to use discretion, right? But clinical discretion. And when you are struggling, I will say you need to consult with someone else. Consult with a supervisor if you are an emerging clinician, or consult with someone else when you feel like you don't know what to do, especially when it comes down to the need to break confidentiality, okay? And so here's the thing. There are so many situations that come up because our field is not a cookie cutter field. We're not just robots, right? And there is a guiding force when it comes to confidentiality regarding the end of life decisions. All right. So there are counselors who provide services for terminally ill people. There are hospice workers or counselors who work with folks who are near death or maybe have chronically ill impairments or disabilities, right? Or diseases, all of the above. Counselors who provide services to terminally ill individuals who are considering hastening. So what hastening means is that they feel like they don't want to suffer. They have lived and experienced all the things that warrant them not wanting to be suffering, right? So counselors who work with them, right? They have the option to maintain confidentiality depending on the applicable laws and the specific circumstances of the situation after seeking consultation, okay, from professional and legal parties. If you are a private practicing therapist and you know that you work with folks who are considering this option because they're tired of suffering, and they remember client welfare, our clients have autonomy to make decisions for themselves, right? And so if you know that you're working with this population and you know that things can be a little bit sticky, you want to make sure that you have consultation legally and professionally, okay? You want to just make sure you're consulting with other people because this is their right. Even if you feel one way or the other as the clinician, is really not up to you, okay? But I do think that folks who work with people who are at end of life have a different sort of like, sorry guys, state of mind anyway when it comes to that. So most of them are kind of well versed in that. All right. So now the court ordered disclosures. So here's the thing. When clients are court ordered or mandated to seek services, you do have some responsibility. Now, I know that we want to give our clients the benefit of the doubt. We want to make sure that anything that we're sharing does not do harm to them. Okay. But something else to remember, guys, is that the law will always trump ethics. Okay. So let's read this one. When ordered by a court to release confidential or privileged information, without a client's permission, counselors seek to obtain written, informed consent from the client or take steps to prohibit the disclosure or have it limited as narrowly as possible because of potential harm. What this means is that, remember how I was saying Consent and disclosure is ongoing. So if you know that you are working with mandated folks who have court orders and have law sort of like tied into their whole counseling process, you want to make it be known, hey, I know you're coming here. I want to let you know that everything that you share with me, I want to respect your privacy. I'm going to keep it confidential unless you tell me that you want to harm yourself or other people. But then also, if the court has subpoenaed me to provide supporting evidence, even if it's just attendance, even if it's just if a client has attended the group or the session, right? This is still something that you want to let the client know that you have to report, okay? You got to let them know, all right? And then we go down to the minimal disclosure. So here's the thing. We want to keep what we share minimal as possible. It's kind of like the idea of protected information, right? And we don't want to do harm to our clients. There are times where we have to break confidentiality. It just is what it is. But we want to make sure that we're only breaking it when it's necessary. So to the extent possible, clients are informed before confidential information is disclosed and are involved in the disclosure decision-making process. So I'm going to give you an example right here. Let's say that you are working with kids. I like this example because a lot of therapists are advocates. That's part of the counseling relationship. We covered it in the Code of Ethics, Section A, the advocacy portion. Many of us will see kiddos and have to sit, or not have to, but we choose to sit and support them in their IEP process and in the school setting, or maybe there are different folks involved in the community or in church, different settings with our clients, and there are releases of information to where we can kind of be active participants, but still we want to make sure that we're not just spilling the beans and just saying stuff that's not relevant or pertinent, okay? But then also making sure we allow our clients to be active participants in the decision-making process. So what this means is that if we are consulting with, let's say they have med management from a psychiatrist, we don't do that as therapists, right? If they say, hey, I think you can talk to them, but don't tell them this, or this is all you can share. We want to make sure that we're adhering to that minimal disclosure request from our clients. That's all that means, okay? And then subordinates. Okay. No, I think I'm moving too fast. Give me 1 second. Let me just make sure I'm following here. Yes, I am. Okay. So subordinate. So counselors make every effort to ensure that the privacy and confidentiality of clients are maintained by subordinates, including employees, supervisees, students, clerical assistants, and volunteers, right? Hear me out. Let's say that you're in private practice or wherever you are, you're an intake coordinator, you're at a CMH organization where you're the clinician, and you know that there is a multidisciplinary support system in place. Everybody has to maintain confidentiality of the client. It is on you as the clinician to ensure that when you are communicating with other folks who are involved, that you are being as minimal as possible. Not because you don't want them in your mix for you as the therapist, but for the welfare of the client, okay? Everybody needs to safeguard client information, period. It is the responsibility of everybody, even if you are simply just the office assistant, okay? Now, here we go with interdisciplinary teams, kind of what I kind of just jumped to. So when the services are provided to the client and when they involve the participation of an interdisciplinary team, so this means that there is a treatment team of different people. For instance, I'll give an example. You are the therapist, so you are that direct one-to-one therapy support. There may be a psychiatrist or a nurse practitioner who manages medications. There could be a psychologist or a psychiatrist who is the doctor, who is the clinical director, if you will. There could be They're just different people involved in the process, right? You want to make sure that the information you share is for the purpose of consultation, right? And that the whole treatment team is aware. The clinician shouldn't know something that can affect our client's welfare and not share it in a minimal and ethically appropriate way to the NP who's prescribing the medication. Let's say the client has told you, hey, I feel like I can't stay awake. And you know that the psychiatrist is prescribing the medication. You may work with the client to be an active participant, to be an advocate for themselves. But if they struggle with that, you may say, hey, so-and-so says that she's sleeping too much. Can you check in with them? Et cetera, et cetera. Okay, so an interdisciplinary approach should be focused on the welfare of the client. Okay, you want to make sure that you're communicating with all of the members of the treatment team. And then we go down to the confidential settings, right? So counselors discuss confidential information only in settings in which they can reasonably ensure the client privacy. Okay. Now, this is super important. I think that we can better safeguard our own offices and our own personal private spaces. But when you are like meeting with someone virtually and you know that maybe they're not in a space where they can just be you and them, and you think that maybe it will violate their right to privacy, like other people are in the background. Maybe they want to meet at a coffee shop, or maybe they have to go to a library or a coffee shop. You still want to make sure that they have headphones in or something, or they're in their own private space, so that you do not put them at harm's risk of violating their privacy. Okay, it is on you as the clinician. At the end of the day, we're in this because of the welfare of the client, right? We can say, oh, well, I think it's common sense for someone to be by themselves during therapy, but not really. Remember, disclosure is ongoing, right? Support is ongoing, okay? And so if you know that your client could potentially be at risk, you want to make sure you are letting them know, hey, I don't know if this is can you go to your car? So then it's only you and me in the car, okay? You want to make sure that they are connected in that way. All right. Moving on to third-party payers. So counselors need to disclose information to third-party payers only when clients have authorized such disclosure. Moral of the story, you can only disclose information when you have been given permission to disclose it, okay? Remember, law will always trump ethics, so there are times where you have to disclose information and clients may not want you to, but you are legally required to. This is when you use that minimal disclosure hat or mind frame, okay? Also, too, so counselors take precautions to ensure the confidentiality of all information transmitted through the use of any medium. All right. Anytime you got to share information about a client or to a client, you want to make sure that you can keep that info confidential. Period. Point blank. Okay. Deceased clients. Counselors protect the confidentiality of deceased clients. Okay. Consistent with legal requirements and the documented preferences of the client. Let's say you are working with a client who is at end of life and they say, hey, I want to put this in my will. I want to tell you this, but I want to make sure that I want this to be said, but I don't want you to tell this family member or that member or family member. That is the client's wishes, okay? Even when they pass on, that information is still protected because legally, in some states, in most states, right, it's pretty standard that you have to protect the client's records for 7 years. You want to make sure, though, you are adhering to the laws of your own state to just make sure that it's 7 years. But even if you have seen a client and they've passed away, you are still responsible for their records, all right? And so group work and families, right? So in the group setting, counselors have to clearly explain all the differentiating parameters. So here's the thing. You want to make sure that you are letting the group members know what they can expect in group. And also something that I like to share is that, yeah, you can tell the group members, hey, as a therapist, I promise to keep your secrets are safe with me. What you share in here, I will not share with anyone else. But there is a chance that someone else can go home to their significant other, even in pillow talk, and tell your business, right? You want to let them know that there are limits to confidentiality. As a therapist, you will keep their information sacred, but other people may not. All right. So couples and family counseling. All right. So in couples and family counseling, counselors clearly define who is considered the client and discuss the expectations and confidentiality. So here's the thing. Even when you are billing a family code, most times you still have to identify a client, right? Especially if you're working with kiddos or children and families, teens and families, you have one client and you can build a conjoint therapy session underneath that one client. You still want to make sure that everybody who's a participant knows the limits of confidentiality, okay? Counselors must seek agreement and document it in writing that all involved parties regarding the confidentiality of information, everybody needs to know. And so in the absence of an agreement to the contrary, the couple or family is considered to be the client. All right. Maybe you are a marriage and family therapist and your client is the couple, right? So then everybody involved in the counseling relationship needs to know about confidentiality, the limits, and what to expect. All right. This is all part of safeguarding our client's information and then also gatekeeping our field and being an ethical counselor at the end of the day. All right. And so in the next section, it talks about the client's lacking capacity to give informed consent. Okay. And so we have a responsibility to our clients and for our clients. So when we are counseling minors or adults who lack the capacity to give voluntary informed consent. So what this means is if you know that they're under 18, they can't give their own consent. They can give us assent, but they can't give us consent. So they need a legal guardian or a parent to give consent. Or we could be working with adults who are mentally disabled or impaired in other ways, right? We want to make sure that we still are able to acknowledge this and be responsible to our clients, right? We have to protect their confidentiality, all the information we receive from them in any medium. If they have a caseworker, if they are wards of the state even, or if they are like in an adult foster care home, right? We have to make sure that we're following our state laws, right? Federal and state laws, all the written policies, and making sure that we are following the code of ethics, right? The process of the ethics code, what we should do in the event the client has not been able to give us informed consent. Does this mean that we have to consult with their caseworker or their legal guardian regarding important decisions? Remember, as a therapist, anything that you share, you want it to be minimal anyway. Make it relevant. Only share the relevant information to all these other mediums or participants, okay? Now, we also have a responsibility to parents and legal guardians. And so we want to make sure that, especially if we're working with kiddos, that we are informing their parents and legal guardians about our roles, okay? And the confidential nature of the counseling relationship as it is consistent to everything happening in our states and with the laws, okay? We want to make sure that we are sensitive to the cultural diversity of families and respect all the rights. So what this means is being sensitive to the cultural diversity of families. Mainly, let's say in many family systems, I'm African American, right? And so in many Black communities, it's a village. And so a lot of times my grandma would pick us up from school. She would be the one communicating with other folks when it came to making decisions for me, even though she wasn't the legal guardian, right? So making sure though that as the therapist, we respect that. And what this means is making sure that we have releases of information from our client and our client's legal guardian to be able to communicate important information with parents, okay? There's no point to withhold information if it's a community, if it is a situation where the client benefits from that sort of family system. Remember, welfare of the client. Okay. We have to work to establish appropriate and collaborative relationships with parents and guardians that best serve our clients. Okay. Now, I just talked about the releases of information. So releases of confidential information. So when counseling minor clients or adults who don't have the capacity or who lack the capacity to give us voluntary consent, we have to make sure that we seek appropriate permission from them or from a third party. So the third party could be their guardians, legal case management, whoever it is. We want to make sure that in such instances, we still inform our clients in some way. Like, hey, right, we use the kid for an example. Hey, I want to let you know that anything that you share with me, I promise, I want to make sure that I respect it and I keep it safe. However, if you tell me that you want to harm yourself or harm someone else, I might have to tell your parent. All right. Or if we're working with an adult who lacks the capacity to give like consent for themselves, if we're working with their case manager or their guardian, we want to let them know, hey, I had to reach out to your guardian because of this. And we need to make sure that we say it in an appropriate way where they can understand it. All right. Now, as we are going over the records and documentation, that is big. Remember, it is your duty as the clinician to safeguard your client's information, period. You must safeguard client information. So what this means is you have to make sure that you are being responsible for their records. We know that in some states, you have to be responsible for client records for 7 years. But remember, rule of thumb, especially as we're approaching the NCE exam, you want to make sure that you are adhering to the laws of your own state, because maybe what happens where you are, Crystal, in Texas, may not be the same for me in Michigan. I think 7 years is the standard, but we just want to make sure that we're adhering to the laws of the state. On to the confidentiality of records and documentation. Here's the thing. I know the rule of thumb is like, if we don't document it, it didn't happen, right? However, we want to make sure that we are only minimally disclosing things that are pertinent to the relationship or the resource or insurance, okay? So what I mean by that is we don't have to just spill the beans for everything that our client is telling us. You only want to include important information. So we want to make sure as a therapist that we are keeping our clients' records safe, whatever EHR system that we use, right? We want to safeguard their information, right? It needs to be secure and only authorized persons have access to them. Clients can request their records, okay? I was working at a group practice and they use like a system which I had never seen before. And so like clients could literally go in and see every single thing. But remember, the welfare of the client, right? Let's say something is in the note that you feel like could be harmful for the client. Okay. This could mean if they are not stable, if they come into your office and they're coming in there guns blazing and they're like, I need to see I want to see my notes, or I need to see this. You could say, for your welfare, maybe we can revisit this next week, right? So we still just want to make sure that we're only sharing information that is pertinent and going to keep our clients safe. Okay. Now, permission to record. Now, this is common sense. There are certain systems or certain instances where folks will say, hey, especially as interns and like student therapists, like they might want to be able to transcribe the sessions or like record their clients. I don't know. I say boundaries, ethics. I would be too afraid. I would say don't do it. However, in the event that you feel like you have to, or it's for an assignment, if you are a student therapist, you have to obtain permission. That's common sense. Don't be recording nobody if you cannot. There are some practices that may have cameras in there depending on the population. And so basically that is information that is included in the disclosure though. So even before somebody is starting a session or joining your practice as a client, they know, all right, I know at this office or at this agency, there's cameras. I signed the disclosure that I can be recorded, but not, maybe they don't have it to where they can hear it because that's that's HIPAA, right? But if it's like a jail, for example, if it's a group, maybe you work with a different type of individual that may have like a disability where they can become aggressive. And for the safety of both you and the client, there may be cameras, but they have to give consent for that. All right. And then permission to observe. So counselors have to maintain or obtain permission from counselors prior to allowing anybody to observe a session. So this could be a peer. You could be a student. You want to make sure you're checking in. Hey, I have someone who wants to shadow me. Or let's say you're leaving a practice and you know that you have to give handoff to the next clinician. You still have to get this okayed with the client. Random people just can't show up in the session. That's a no-no. Okay. Now, let's talk about client access because they do have access to their records. They can request their records. They have the autonomy and free will to do so. Okay. They can whenever by competent clients, right? So counselors limit the access of clients to their records or portions of their records only when there is compelling evidence that such access will cause harm to the client. So what I was basically saying, if you know that there is something in their records that can do them harm, you are ethically responsible to limit what they have access to, okay? Because at the end of the day, maybe we needed to write it because we have to make sure that we're being ethical therapists and we are documenting things with fidelity, but at the same time, only minimally disclosing important information relevant to the session and for insurance. And if you know that something in that note is going to harm someone, they don't need to have it, okay? They don't need to have it. And so in that situation where maybe there could be multiple clients, you have to make sure that you provide the individual clients with only the part of the records that directly relate to them. If it's a couple or a family, if you know that you met with one of the parties or the couple members of the couple individually, the other person don't need that record, all right? You didn't even meet with them, okay? It seems like common sense, but in hindsight, anything can happen. And sometimes it could be a mistake on the therapist's end. But if it wasn't in the Code of Ethics, it happens all the time, clearly. That's why it's in the Ethics Code, okay? Now, so when a client is requesting their records, right, we have to make sure we provide them with assistance in interpreting their counseling records. This is why I always say the best thing in a session, now this is a little bit of a personal opinion. As a therapist, you don't have to just bombard folks with therapy jargon that they don't understand. Clearly, if they are struggling to understand, it is your responsibility as the clinician to support them and help them to understand, period. That's what that means, all right? And now disclosure or transfer. So unless exceptions to confidentiality exist, counselors obtain written permission from the clients to disclose or transfer their records to third parties. What this means, if you know that the client is transferring to someone else, let's say that you are working with a client who has previously worked with another therapist and you're interested in their records because it's going to benefit your specific counseling relationship with them in the hopes of giving them a better outcome, you got to get permission, okay? Folks not just going to be releasing people's records for nothing, okay? And so now, Storage and disposal after termination. Remember, it is on you as the clinician to safeguard client info, period. You have to be a keeper of the records, all right? So you have to store them following termination to ensure reasonable future access. So in many EHR systems, they just kind of live there. Sometimes when folks discharge, we can send their stuff with them, but you still have to kind of keep it in a record. We have to apply careful discretion and deliberation before destroying records. When I was in internship, way back when, 2018, the place I was interning at, they still did shorthand records, but they had lock keys up like in the upstairs attic. It was like a runaway shelter home kind of vibe. Even when clients or kiddos left, those records stayed there, locked and safe, right? They were stored, okay? I don't actually know when or if or how they were terminated, but only particular folks had access to that, right? Now, because there are different things that come up, because this is not a cookie cutter field, we have to be aware of the reasonable precautions. So counselors take reasonable precautions to protect client confidentiality in the event of the counselor's termination of practice, okay, incapacity, or death, and appoint a records custodian when identifiable as appropriate. So here's the thing. Now, I know this is really important for like a private practice person. You want to just make sure you have all these things in place. I know at an agency, it's easier to be like, you know, the precautions are kind of already there in a way because you have support. Other people are there. But you want to make sure as the therapist, you're still protecting the client's confidentiality in the event that you leave or something happens to you, okay? Safeguard the information in a way that somebody else will be able to have access to it if needed, all right? And then case consultation. The biggest thing about case consultation is not a vent session for you as a therapist. I know it could feel that way, especially if it's a tough case and you're struggling, all right? You want to make sure that any information that you share is only shared for the sake of a professional relationship. Example, if you know that you are attending any sort of like meeting or session for a client, that's your client in an outpatient practice session, but you're meeting maybe with a teacher or an instructor or someone else, you want to make sure that you're still respecting their privacy. Or if you have your own clinical consultation, you still have to respect the privacy of your client. So that means that all the written and oral things that you say need to be protected in a way that you make sure that you don't invade their privacy. Only share pertinent information relevant to whatever's happening or whatever you're consulting about. If they came in and told you about their whole background, nobody needs to know that but you and them. All right? And then lastly, in section B is a disclosure of confidential information. So when you are consulting with your colleagues as a clinician, you cannot disclose information that could lead to the identification of a client, right, prior to their consent. Now, I think the biggest thing for like supervisees or like interns, your clients need to know that that's what you are. If you are an limited or provisionally licensed clinician, they need to know that you are under supervision and you do have consultation, right? Consent and disclosure is ongoing. Okay. They disclose information only to the extent necessary to achieve the purposes of the consultation, period. All right. Now, this stuff seems to be common sense, but we all need a reminder here and there. Okay. Let me know if you guys have questions. We got through that pretty quickly.